Welcome to the webinar. My name is Rob Morris. I'm with the Trust and Estates Department of Stark & Stark. A little bit about Stark & Stark before we actually begin the webinar. Stark & Stark is a full-service law firm. Obviously, we do trust and estates, guardianship, and estate administration work, but we do a variety of other types of law, everything from business transactions to family law to obviously personal injury. If you have any legal related needs, you're welcome to contact the firm's general number or call me directly. My direct number will appear on the final slide if you'd like to reach me. What you see on the screen now is a brief outline of the major topics we're going to cover during today's seminar. The first one will be the required beginning dates for distributions. We're going to talk a little bit about the changes to the distribution scheme that have been made by the Secure Act and the Secure Act 2.0, as well as the IRS regulations. And then lastly, we're going to talk about a few estate planning opportunities and options as a result of these changes. Okay, so the first slide you see here is when is the owner required to take distributions on traditional plans. Please keep in mind that Roth accounts do not have any required distributions for the original account owner. And what I'm referring to there is the person that creates the Roth account in the first place. So before the Secure Act changes, everybody was required to take distributions at age 70 and a half. After the Secure Act, if you were born on or before July 1st, 1949, there's been no change in that. You're still obligated to take required distributions beginning at age 70 and a half. Following the Secure Act, there's been a few additional ages that were implemented, and they have limited application, which you see on the screen. So for plan owners who were born on or between July 1st, 1949 and December 31st, 1950, you're required to take distributions starting at age 72. If you're born between January 1st, 1951 and December 31st, 1958, as well as the regulations will also include persons born in 1959, you're required to take distributions from your traditional plan account starting at age 73. And for all plan owners who are born January 1st, 1960 or more recently, your required distribution date is now age 75. So the benefit of this, if you're younger and you fall under the age 72, age 73, or age 75 distribution, is that you can continue to keep assets in your IRA or 401k longer, and that you're not going to be required to take distributions until you have a later age. All right, here's a retirement account timeline for traditional IRAs and 401ks. So the first age deadline that you need to keep in mind is whether you're age 59 and a half or younger. So if you have not attained age 59 and a half, there's a 10% penalty for what are deemed to be early withdrawals from the account. Now, there's a lot of exceptions to this rule. There are way too many to go through in today's seminar, but there are some exceptions for various emergencies. But in general, if you're younger than age 59 and a half, you're not going to be allowed to take distributions from your own retirement account. Again, for individuals age 72 or 3, depending on when your birthday falls, then you're going to start having to take minimum distributions from your traditional IRAs and 401ks, 403bs, etc. All right. If you're 75, for individuals born after January 1st, 1960, obviously you haven't gotten there yet, but if you're 75, then you're going to be required to take distributions when you reach age 75. And those are going to continue until the account owner's death. There are some distribution requirements for your beneficiaries following the account owner's death, which we're going to go into in quite a bit of detail. And those end at the required withdrawal period, and that varies. So the end of the required withdrawal period varies depending on some of the attributes of your beneficiary. We're going to talk about all those in quite a bit of detail in a little bit. Please keep in mind that there's a 25% penalty for late distributions from your traditional account, so it's important that you be taking your distributions as required. The penalty used to be 50%, was pretty considerable, but it's been rolled back to 25, which is enough in and of itself. All right, here's the timeline for retirement accounts for Roth IRAs. So again, you have the same early withdrawal penalty, 10% penalty for withdrawals before age 59 and a half. Again, there are no withdrawals during the account owner's lifetime, but following the death, there's likely to be distribution requirements on the Roth IRA as well. And there is also a 25% penalty for late distributions. Again, we'll go into the end of the required withdrawal period for Roth IRAs in a lot of detail here in a little bit. All right, in 2025, there have been some increases in the contribution limits for those of you who own 401ks, 403bs. They're now $23,500, all right, which is quite a bit of money. If you're over age 50, in addition to that, you can also do catch-up contributions in the amount of $7,500. If the plan permits, plan participants who are within the 60 to 63 age group can do catch-up contributions up to $11,500 and $5,250 for simple IRA plans. Right now, catch-up contributions have to be made entirely to a Roth plan if your income is $145,000 or more. All right. Note that the Roth IRA income contribution limit is $150,000 for single, and if you're married, it's $236,000. So if your income exceeds those amounts, you can contribute also to a Roth IRA. And please keep that in mind. So if your income is under those limitations that we just ran through, so if you're making less than $150,000 as a single person or $236,000 as a married couple, you may want to consider Roth contributions to a Roth IRA, which you can do in addition to having a 401k at work. All right, there are some creditor protections, which are always nice for IRAs and 401ks. Right now, the federal bankruptcy exemption, so if you are forced to undergo a bankruptcy and you have an IRA, you can exempt up to $1.7 million. All right. The benefits for ERISA, I understand, are much higher. Those cover SEP IRAs, simple IRAs, 401ks, 403bs. They're all covered by ERISA. There's a lot more bankruptcy protection for those types of plans. My understanding is basically unlimited. Inherited retirement accounts, please note the Supreme Court decision, Clark versus Ramaker, which basically said that inherited retirement accounts don't receive any bankruptcy protection, at least at the federal level. All right, and that is a big distinction from the account owner. So again, what's the difference between the first bullet point and the third? If you are the account owner of the IRA, that is something that you've created and contributed to, you can exempt up to $1.7 million as set forth on that first bullet point. However, if you have an inherited retirement account, so you didn't create it, you just inherited it from somebody else, the Supreme Court decision there says that you're not going to receive any bankruptcy protection. Please also keep in mind that there are separate state laws which do exempt IRAs. Those depend on what jurisdiction that you're in. But some states will allow basically an unlimited exemption for an IRA. So that also affects the bankruptcy limits that you see there on the slides. All right, so earlier we talked about the IRS regulations, which came out for the Secure Act and how they affect beneficiaries. So there are two main issues when you're considering these. First of all, what are the required minimum distributions each year? All right, so how much are we required to take out each year as a beneficiary? And then the second issue you need to consider is that there's a termination now on a lot of these inherited accounts. So there's going to be a limitation period for the complete distribution of the account. In many instances, when you're dealing with a non-spouse beneficiary, just to advise you now, is that's going to be a 10-year payout period. There are for a few exceptions to it, which we'll go through. But again, there's two main issues. Number one, how much are we required to take out each year? And number two, what's the overall limitation period for complete distribution of the account? All right, so the first group we're going to talk about is the surviving spouse. All right, and the surviving spouse has a couple different options. First of all, a surviving spouse can do what's called a spousal rollover. All right, what that allows the surviving spouse to do is roll over an inherited IRA or 401k into an IRA that the surviving spouse creates. And essentially, the surviving spouse can treat that spousal rollover account as if they had created it from the beginning. So that's a option that's unique to a surviving spouse. In the alternative, the surviving spouse can treat the IRA or 401k as an inherited account, right? So the main difference there is if you do an inherited account, you're likely to have distributions immediately. All right, and then there's two issues on an inherited account. That's why there's two different slides there. So the first issue is, did the plan owner's death occur before the required beginning date? And the second issue is, on an inherited account, did the death of the plan owner occur after the required beginning date? That's an important distinction, and we're going to cover here in a few seconds why that is. All right, so a spousal rollover. Does the spouse want to do a rollover? So that's kind of the first consideration if you're the spouse. Do you want to do a rollover and treat it as if it's your account from the get-go, or do you want to do an inherited account? So why would you want to have those two differences? So the main issue relates to that account payout timeline that we covered earlier, and was the very first bullet point. So if you're under 59 and a half and you do a spousal rollover, what's that mean? Again, under the payout period there, that means that you now have an early distribution. So if you do a spousal rollover and your surviving spouse is under 59 and a half, well, guess what? They're not going to be able to take distributions from the account without incurring a 10% penalty unless one of those various exceptions applies. So if you do have a younger spouse and they need to access the IRA or 401k to pay for life expenses, supporting the home, education for the kids, et cetera, the surviving spouse may want to consider either a partial or a complete treatment as an inherited account. And again, there's going to be differences depending on whether the death of the plan owner occurred before the required beginning date or after. All right. If there is a spousal rollover, you're going to use the spouse's age for the required beginning date. So the example is the decedent is 71 and the surviving spouse is 65. Okay. Harkening back to one of the very first slides that we did here, the required beginning date is likely to be age 75 for the spouse. So the spouse wouldn't have to take distributions from a traditional account until age 75, okay? As opposed to use the decedent's required beginning date, that's only 4 years away, right? So the spouse will get 10 more years of no distributions on the account. Again, you see the second bullet point there. If the spouse is under 59 and a half and needs distributions from the retirement account, you're going to want to consider at least a partial rollover, or excuse me, a partial rollover and treatment as inherited, or you're just going to want to take the entire account as an inherited account. Another issue too is some of the plans might impose a 10-year distribution rule. All right. And that may be imposed on the spouse as well. And that's covered by the plan. It's not imposed by statute or regulation. So if the plan imposes a 10-year distribution rule on the spouse, then that rule is going to carry over to any rollover that the surviving spouse does to an IRA. And if the rollover occurs after the surviving spouse becomes subject to mandatory withdrawals, so again, the surviving spouse is over age 75, then the rollover is reduced by the amount of the required withdrawals that occurred before the rollover took place. So a lot of gobbledygook there on the last bullet point. Let me try and cut through that. All right, so what's that talking about? So Surviving spouse doesn't have to roll over the account right away. What it could do is, suppose instead of the decedent being older than the surviving spouse, the decedent's younger than the surviving spouse. So the decedent is, let's just say 71, the surviving spouse is 76. Well, if they'd rolled over the account right away after death, the account would be subject to mandatory withdrawals immediately. So suppose the surviving spouse attempts to game the system, right? So they wait to do a spousal rollover for a few years, then they do it, and then they'd say, oh, now I've done the spousal rollover. Now I'm subject to distributions from the retired account. I didn't pay them in the years before because it was still in the decedent's name, and try and game the system a little bit. So the IRS regulations caught on to that, and they obviously disallow it. So if you roll over the IRA after the spouse becomes subject to minimum withdrawals, well, guess what? Now you're going to end up having to go back and take all the required distributions over the period that the spouse attained, likely age 75, until whatever age the spouse is now. Okay, so the other issue is for a spouse is how much of distributions are we required to take in each year. So in order to understand that, you need to understand the uniform lifetime table versus the single lifetime table. So let's take a look at the tables first and run through some examples, and then we'll come back to the surviving spouse. So what you see on the screen right now is a copy of the uniform lifetime table. So you see the ages in the left-hand column, and you see the distribution period. So for example, if you're 74, the uniform lifetime table has a distribution period of 25.5. And I have some samples laid out on the right side of the slide. So at 72, the distribution period is 27.4. If you're 80 years old, the distribution period is 20.2. If you're age 85, the distribution period is 16, and so forth on down. All right. In comparison, here are the single life tables, right? So on the single life table, if you're 72, for comparison purposes, the life expectancy is 17.2. All right. And if you're 80, life expectancy is 11.2, 85, 8.1. You can see the numbers there side by side for those various comparison ages, uniform versus single. As you can see, the uniform numbers are much higher, right? And what's going to end up happening is the higher numbers are going to be more beneficial for the surviving spouse in this case. All right, but for any plan owner. All right, and we'll show you here in a second. All right, so suppose, for example, you have an inherited traditional account. So that's pre-tax, right? A lot of people think of them as pre-tax or Roth. So what we're talking about is a pre-tax traditional account. The spouse is a beneficiary, and the death of the plan owner occurs before the required beginning date. So in other words, let's just say the owner was required to start taking distributions at age 73, and they died at age 70. All right, so they never hit their required beginning date. So when do required distributions commence for the surviving spouse? So this is an inherited account. So that's going to be the end of the year in which the employee decedent would have attained the required beginning date, or the later of the year after death, whichever comes first. All right. The distributions are calculated using the surviving spouse's life expectancy. All right, and they're going to be on the uniform life table that we just talked about in a second. The other nice thing is that the distributions are redetermined each calendar year. So you're getting an annual recalculation. Again, I'll show you what that means. And the distribution period is the life expectancy payout during the spouse's lifetime. All right, so after the spouse's death, the account has to be paid out in the earlier of the single life expectancy or after 10. All right. So we talked a little bit about calculation versus recalculation. All right. And where that fell on this slide is, you see that's the second group there. How are distributions calculated? They're redetermined each calendar year. So what does that mean? All right. So if the employee dies at 72, right, and you're recalculating, right? So at 72, the single life expectancy would be 17.2. Recalculation would also be 17.2. So at 73, if you're not doing recalculation, you just subtract 1 each year, right? So you've increased the year in age, we're going to subtract a year under no recalculation. So we went from 17.2 down to 16.2. If we're recalculating our distribution period, what you do is you go back into the table, right? So you go back into the table at age 73. If you go back into the table, the number is 16.4. So you see that number is slightly larger. Again, larger numbers are going to benefit the plan owner while they're alive or the beneficiary after the plan owner's death. Again, the larger the number, the more beneficial it is to the owner because they have to take less out from the account. So that's the difference between no recalculation and recalculation. So again, no recalculation, you're starting off with, okay, when do we have to take distributions for the first time at age 72, for example, 17.2, and then you just start subtracting 1 every year from that until you get all the way down to 1.2, and then you're basically having to pull the entire account out. If you're recalculating, you're going back into the table each year, right? So again, you start at 72, you go into the table. You hit 73, you go back into the table and you take the life expectancy number out. All right, so recalculation is slightly more advantageous for the owner. All right, so we have an inherited account, the spouse is beneficiary, and death occurs after the required beginning date. So here we have the employee or plan owner who dies after the required beginning date, and the spouse is the beneficiary. So the first thing that you need to consider is when do distributions commence? All right, so the employee already hit the required beginning date, so they start annually, including the year of the employee's death. All right, so distributions start right away. How are distributions calculated? So you get the longer life expectancy, whether you're using the spouses or the plan owners. So you take the two of them, whoever has a longer life expectancy, you can use that if you want. The surviving spouse recalculates annually until the surviving spouse's death. All right. If you're using the employee's life expectancy, then you cannot use recalculation. All right. And the table can be either one. You can either use the uniform table or the single life table. The spouse would elect which one they prefer to use. Generally, it's going to be the uniform table, as we discussed earlier. The uniform table allows for lower distributions each year. The distribution period is the earlier of the single life expectancy payout or 10 years after the spouse's death. So again, if the death occurs after the required beginning date for the employee and the spouse is going to be the beneficiary and treats it as an inherited account, you're going to likely use the spouse's life expectancy as opposed to the employee's. And the account is either paid out using those charts that we talked about, or if the surviving spouse themselves dies during the payout period, then you get 10 years after the surviving spouse's death, and then the account has to be entirely distributed by them. All right, so another comparison again, just to reemphasize the difference in the numbers. So again, the larger the number you're pulling off the table, the better off it is, in my opinion, for the plan owner. So here you have somebody at 72, the uniform table, the number you're going to use is 27.4. If you're using the single life expectancy table, you're only using 17.2. So using a hypothetical account value of $1 million, what you do is the value of the account at the end of last year, so December 31st at the end of last year, what was the account worth? So hypothetically, let's just say it was worth $1 million. If you're using the uniform table because you're age 72, you divide the $1 million by 27.4, and your required distribution is 36,000. As opposed to using the single life table for the same account value, right? So again, the account was worth $1 million as of December 31st of last year. You go into the single life expectancy table, you have a lower number, 17.2. Now you can actually see, the difference here. The lower number results in a much larger required distribution of 58,000. All right, so pretty substantial difference there between the two tables. So again, kind of rule of thumb is the uniform table is much better off for the account owner and the surviving spouse. Generally, the other beneficiaries are all required to use the single life table, which results in a faster payout period. All right, so going back to our scenarios, here we have an inherited account. So now instead of the spouse inheriting the account, now you have an adult, non-disabled child, right? So this is generally the surviving spouse. That's who we're talking about here. So the first spouse is dead. So now you have the widow or the widower. Who are they going to leave it to? They're going to leave their account to their children, right? So if the death occurs before the required beginning date, and this is on a traditional account, and all Roth accounts. So here's where the Roth accounts are going to start coming in. So the Roth accounts are covered under this slide. All right. So when do distributions commence? All right. So there's no required distributions in years 1 through 9 following death. All right. The distributions are not recalculated because they're not required. All right. And we're not using a table because, again, we're not requiring distributions. However, we do have a termination date right here. All right, and here's where it starts getting important because you have an adult non-disabled child. This is going to apply uniformly to all these accounts, right? It's 10 years after the employee's death, all right? And that's going to be the requirement on all these accounts. But here we're just talking about Roths and traditionals before the required beginning date. All right, so the account has to be entirely distributed 10 years after the employee's death, right? And that's important to keep in mind because go back, what was our penalty for blown distributions? Our penalty for blown distributions is 25%. So if you decide to hoard the whole account, wait all the way out to 10 years, oops, it went 11 years, went too long. Well, now you've got a 25% penalty you're going to have to contend with, all right, and figure out how you're going to deal with that. So it's important to keep in mind these accounts have to be entirely distributed within 10 years of the employee's date of death. All right, so here we have an inherited account, also a adult non-disabled child, and death occurs after the required beginning date for the employee. So again, this is a traditional account. It's inherited. It's going to the surviving spouse's adult non-disabled child. So when do distributions commence? Well, they're going to start right away. All right, that's annually, including the balance of the employee's remaining required distribution for the date of death. They're calculated using the beneficiary's life expectancy. So again, if you're talking about a child, it's going to be the beneficiary's life expectancy is longer. If the individual doesn't have a child and they put a friend on, well, perhaps the friend's older than the decedent. If that's the case, then you're going to use the employee's remaining life expectancy, which is an option. All right. The table, now we're using the single life table. So again, kind of the rule of thumb for today's discussion is the single life table is going to require the account to be paid out faster, all right, than using the uniform life table. There's no recalculation. So what that means is you go in, if you're using the beneficiary's life expectancy, you take that life expectancy in the first year, and then you just start subtracting 1 from that life expectancy each year. And that's going to give you the amount of the required distribution each year. The period, again, is the earlier the life expectancy payout. So if you got an old employee and a very old beneficiary, then perhaps using the life expectancy payout, it's paid out in a period that's shorter than 10 years. Unlikely, but possible. All right. More likely is that you, again, have the 10-year termination date. So again, the account has to be entirely paid out within 10 years after the employee's death. Again, very important deadline to keep in mind. All right, so here we have an inherited account with a minor child, okay? This has to be a minor child, not a minor grandchild, not gonna work. Has to be a minor child of the plan owner. So obviously, more likely than not, the death is going to occur before the required beginning date. So when do distributions commence? They're going to be annually using the child's life expectancy. The distributions are calculated using again, the beneficiary's life expectancy on the single life table with no recalculation. The distribution period here is slightly different. Again, this is on a traditional account. The distribution period has to be 10 years after the child's death, which hopefully doesn't occur, but it's there, or more likely the child's 21st birthday. So the account has to be paid out entirely by the time the child's age 31. All right, so here we have an inherited account, minor child. Death begins after the required beginning date. Again, distributions commence immediately, including the year of the employee's death. They're calculated using the beneficiary's life expectancy on the single life table with no recalculation. And you get the same payout period. So the child hits 21, then you have 10 years after that in which to entirely withdraw the account. Or you can use the earlier, the 10 years after the child's death, which hopefully, again, doesn't happen, but unfortunately does occasionally. All right, so the last group we're going to talk about are disabled or chronically ill beneficiaries. These individuals are defined by the regulations. There's quite a few different ways to be deemed a disabled beneficiary or chronically ill. In general, if you are receiving means-tested government assistance, most likely through supplemental security income, that's Social Security, then you're likely going to fall into one of these two categories. All right, these individuals, you can use the beneficiary's life expectancy in which to take distributions. All right, and you don't have the 10-year payout period. So these are one of the few types of beneficiaries where you can continue to use the life expectancy payout, and you don't have to worry about the 10-year limitation during the disabled or chronically ill beneficiary's lifetime. All right. In general, because these individuals are oftentimes receiving means-tested government assistance, you're going to want to take these accounts and pay them into a special needs trust, which would allow the individual to maintain their eligibility for governmental assistance, which automatically means you're using a accumulation trust. So accumulation trust simply means that all the distributions are going to be withheld and retained in the trust and then paid out of the trust by the trustee, more often than not to third-party providers who are helping out the beneficiary. All right. So there's a lot of rules on these. Bottom line for today's discussion is that A, the trust has to be structured properly. You need a special needs trust for these types of beneficiaries, and the special needs trust has to be an accumulation trust. All right. What are some reasons for trusts in general? All right. So we've walked through the various scenarios that apply to different types of beneficiaries. So why would you want to consider a trust? All right. So if you have a minor beneficiary, to me, you really need to have the assets payable to a trust. All right. Because you only have two options if the assets are paid to a minor. And when we're talking about minors here, as opposed to the payout period, a minor would be somebody under 18. All right. So for purposes of the payout period, a minor's 21, but for purposes of this discussion here, a minor's under 18. All right. And the difference is if you're under 18, you can't have assets in your name, right? You need to have either a guardian, like an UTMA account, in place for you, or the assets have to be either in trust or paid to the surrogates fund. All right, because you don't have legal authority to enter into contracts and nobody's going to deal with you. If you're older than 18, then technically the account could be paid to you and these issues become a little bit less. But in my mind, 18 to 30, you have an asset management issue. So it's still not a good idea. All right. So for minor beneficiaries who are 18, you have two options. All right. So number one, the guardian, who could be a surviving parent. All right. So they're even going to require a surviving parent to do this. I know this because I've been through it many times, right? So if you pay your IRA directly to a minor child, right, who's under 18, and there's a surviving parent, even they will have to be bonded, and they're going to have to be bonded for the entire value of the account. The other thing is the bonding company makes you front end the payment. So what I'm talking about there is, say the kids are 11, the premiums are paid annually until the child reaches age 18. So the bond has to be front end paid for the entire time from age 11 all the way through age 18, which is very expensive. So that's option one. That would allow you to maintain the assets in the IRA. So that's the benefit of doing it. But the downside is the surviving parent has to be bonded for those assets. All right, so option number two is you can say, I want to avoid the bond. But option two is, we're going to have to do a complete withdrawal, like immediately. So the entire account has to be entirely withdrawn and deposited with the surrogate's commingled fund for minors. All right. Also not a good plan because now you're losing all the benefit of the stretch period. And for a minor, remember, that's all the way out to age 31. So that might be quite a long time. All right, you've just lost all that. Second, if we're talking about a traditional plan, you do the withdrawal, what are you going to have to pay? You're going to have to pay income taxes because remember, all the money that you withdraw, even if it's being deposited into the surrogate's fund, you're still going to owe income taxes on that account. So, and then the surrogate will hold those assets that you've deposited in the surrogate fund. They do a nice job, but they generally only earn interest at what you would expect to see for like a CD at a bank. So we're really talking about 3, 4, maybe 5% if you're lucky per annum on interest at the surrogates fund. Perhaps you could do better maintaining the assets in the IRA, and then you can invest them as you see fit. So again, that's a good reason for a trust. We've got a minor beneficiary. The trust has to be structured properly so that we can use the minor beneficiary's life expectancy, that would be to age 31, to make those distributions. Because if we don't do it, you're either going to have to be bonded or the money's going to be paid to the surrogates fund, both of which are major setbacks financially. All right, perhaps an equally as important reason is asset protection, right? So another reason for trust is asset protection. Here, we're concerned about what the beneficiary is going to do with the account, right? Because I've seen many times, again, not all, but many times, the beneficiary just swoops in and then entirely withdraws all the money from the IRA, right? Within year one. Now we've incurred a lot of taxes and we've lost the stretch period. And what do they do with the money? Who knows? I don't always hear what happens with the money, but the few times I have been told, not exactly impressed. All right, so asset protection can hopefully address marital issues for the beneficiaries, right? So if the beneficiary goes through a divorce, and the IRA money's payable to a trust opposed to payable directly to the beneficiary, it's likely that the trust will receive enhanced protection as opposed to just paying the assets directly to the child. Perhaps this child has spending or financial management issues. All right, they just simply can't manage the money. You just talked about that. Here you'll see the entire account being withdrawn within a very short time period, losing all the tax benefits of the IRA. Related issue, and this one's kind of sad, is dependency. Unfortunately, we're starting to see more and more of this, where the beneficiaries have drug addiction. They may be addicted to drugs, alcohol, what have you. In which case, if you leave one of these types of beneficiaries money, right, where's the money going to go? It's likely going to go to fund the dependency issues. So for those types of individuals, more often than not, you're going to want to have a trust in place to address what they're doing with the money. All right. So one type of trust, we talked about an accumulation trust earlier in the context of special needs, right? Accumulation is where the IRA distributions just stay in the trust, right? The other type of trust is a conduit trust, which is what you see here. Here you have an inherited IRA account that's being paid to the conduit trust. And then the trust just takes the minimum distribution each year and then passes it on to the beneficiary. You may like this type of trust. It provides protection for the IRA account over the course of the stretch period. And it allows for the minimum distributions to be paid out to the beneficiary as opposed to being retained in trust. Either will work, either being either a conduit trust or an accumulation trust. But this type of trust is also available as well. All right, the accumulation trust that we talked about here the retirement account is being paid into the trust and then it stops, right? It stops in the trust. And then you see at the bottom of the slide, the trustee can make discretionary distributions for the beneficiaries of the trust. This is slightly less advantageous tax-wise in many circumstances. That's simply because the trusts generally pay income taxes on a compressed rate schedule. But aside from that issue, it would address some of the spending, the financial mismanagement issues that you see with many beneficiaries. And again, if you have minor beneficiaries, you're probably going to want to go this route. All right. With these types of trusts, the trustees given broad discretion as to how to make distributions to the beneficiaries. Again, you need to keep in mind these trusts have to be properly drafted. For example, the beneficiary's age is all an issue here. You can't have one beneficiary on the account that's older than another. Say, for example, beneficiary 1 dies, and now you've got beneficiary 3 coming into play as a contingent beneficiary, and beneficiary 3 is older than 1, then that's going to cause some issues with the payout period. So it's important that these types of trusts, the accumulation trusts, be drafted properly so that you can protect that 10-year payout period or longer, depending on the type and age of your beneficiary. So an accumulation trust retains the accounts in the trust. All right. Briefly, I'm going to talk very briefly about estate and inheritance taxes because I know everybody's interested in them. All the retirement accounts that we talked about are incorporated into the value of the gross estate, and that hopefully the gross estate is worth less than the federal unified exemption amount. So right now, federally, that exemption amount is $13.99 million per person. Next year, we're slated to go up to $15 million per person. All right. Just because your 401k or IRA is paid to a named beneficiary means it gets out from under this type of taxation. It does not. All right. That account is part of the gross estate for these types of taxes. So it's important that you look at the value of your IRAs and 401ks as part of the broader picture for your estate. And that would include all of your real estate and other assets that you have. Some of you may have small businesses. These are going to be valued for purposes of the estate tax. And then tax again if you're over these exemption amounts and you're leaving assets to kids or other types of beneficiaries. So it's important that you consider these types of taxes as part of your overall evaluation of your IRA or your 401k. Please also keep in mind that both New Jersey and Pennsylvania have inheritance taxes. All right. They're structured a little bit differently. New Jersey, for example, is not going to impose an inheritance tax on spouse, children, grandchildren, and so forth. New Jersey inheritance taxes would apply to distributions to siblings, cousins, and more remote family members. All right. It would also apply to friends. So if one of those individuals is a beneficiary of your IRA or 401k, well, guess what? Now they're going to have an inheritance tax imposed on the account as well. And New Jersey and Pennsylvania is going to impose that inheritance tax on the full value of the account. So they're not going to give any credits for traditional accounts that have these embedded income tax obligations in them. So for example, if you receive the $1 million IRA that we talked about earlier, and that's payable to a cousin, now you've got a 15% New Jersey inheritance tax on the first 700,000 and 16% on the remaining 300,000. All right. And the beneficiary is likely to withdraw the money from the IRA to pay the tax, and then they end up having to pay income taxes on the amount they paid in New Jersey to fund the inheritance taxes. So again, please keep those in mind. PA's inheritance tax is structured slightly differently. Again, there's a spousal deduction, but it's 4.5% to linear descendants. So PA will tax children. New Jersey doesn't. PA does. And then it has higher tax rates for more remote beneficiaries. I put likely on the PA inheritance tax because I believe there is an exception that if you die before hitting 59 and a half, I think is the age, then it's possible the PA inheritance tax would not apply to your IRA, but otherwise it will. All right. So it's important that you keep the federal and state estate and inheritance taxes in mind when viewing your overall account as well as your estate plan. So I appreciate everybody coming today. It's 12:45 now. We're just going to conclude. So keeping in mind, the Secure Act made some pretty important revisions to IRAs and qualified retirement plans. The two main issues with regard to all those accounts in the Secure Act are, one, what payout period are you using to pay out the IRA or 401k to the beneficiary? We talked about that may vary depending on whether the beneficiary is a spouse or other type of beneficiary. And then the second major issue that the Secure Act is involved in is, what's the termination period, right? So how long can we continue to maintain an inherited account? Again, for most beneficiaries, that's going to be 10 years. For a surviving spouse, that may be longer. And for a chronically ill or disabled beneficiary, again, that may be longer. For minor children, it's age 31. Everybody else is 10 years, right? So for 9 times out of 10, the beneficiary is an adult child who's over age of minority. So they're going to end up having a 10-year payout period, and they're going to have to completely withdraw the IRA or 401k within that 10-year period. Very important deadline to keep in mind. And lastly, don't forget, again, the major non-tax issues in estate planning which apply to IRAs and 401ks. Maintaining the stretch period is nice. Avoiding taxes is nice. But if you're passing an IRA to somebody who just can't handle it, right, this is not in their skill set, then you really need to be considering a trust for the IRA. And the same thing, if it's fairly large and you're concerned about, in particularly a child, a marriage or what their long-term situation is like, you need to be considering a trust for these types of assets. Obviously, you've worked hard. You've accumulated the assets in your IRA or 401k. That's your work product right there, right? Where does that come from? Comes straight out of your wages, right? So it's important that that be handled by your beneficiaries, seeing how much effort you put into creating the account. Hopefully the beneficiaries will put equal amount of effort into maintaining the account going forward. So if you have any questions, like I said in the beginning, there's my phone number, 609-945-7617. My email, you're welcome to call or email me with questions. And lastly, I'll just put up here, there's a couple of disclaimers, but they are important. The most important one being, everybody's situation is different, right? So what we talked about are general rules today. Your specific situation may be different or require some individualized attention. All right, so it's important that you don't try and rely on generalized rules when addressing your specific situation. Again, if you have questions regarding anything that involves your IRA or 401k, you're welcome to call me or email me. One more time, 609-945-7617. And thank you very much for attending here today. Have a great day.